Bissonnette et al. Versus LePage Bakeries, Park Street, LLC et al. 2023. Bissonnette and Wojnowski was to distribute Flowers products. They are not transportation workers. They are not exempted from FAA. Transportation workers are not the only people who should be FAA exempted. When Bissonnette and Wisnowski sued violating state and federal laws, Flowers wanted the Federal Arbitration Act to apply to them. Bissonnette and Wisnowski are contract employers. They transport, found new retail outlets, advertise, set up promotional displays, maintain customer shelves, replacing expired products. This is a 9-0 decision, with Roberts writing the opinion. Flowers Foods, Inc. is the second largest producer and marketer of packaged bakery goods in the United States. The flagship product is Wonder Bread. Flowers is not solely responsible for getting the baked goods to geographic territories. The distributors purchase the goods from Flowers and then market, sell, and deliver to retailers. Bissonnette and Wisnowski were franchisees who owned the rights to distribute in certain parts of Connecticut. They allegedly spent at least 40 hours a week delivering Flowers products in their territories. They found retail outlets, advertised, set up, maintained inventory, etc. To purchase the rights of their territories, Bissonnette and Wisnowski signed a distributor agreement with Flowers. In 2019, Bissonnette and Wisnowski filed a punitive class action claim stating that Flowers underpaid them in violation of state and federal law. The claim was Flowers took unlawful deductions from their wages and failed to pay them overtime and unjustly enriched itself by requiring them to pay for distribution rights and operating expenses. Flowers moved to dismiss or compel arbitration under the FAA, arguing that contracts required distributors to arbitrate their claims individually. Bissonnette and Wisnowski contend that they are exempt from FAA because they engage in interstate commerce. The district court dismissed the case in favor of arbitration because Bissonnette and Wisnowski were more than transportation workers. Without addressing the district court analysis, the Second Circuit affirmed the alternative ground that Bissonnette and Wisnowski are in the bakery industry. Within a month of this decision, the Second Circuit decided in the case Southwest Airlines Company versus Saxon that the ramp supervisor who would frequently load and unload cargo engaged in foreign and or domestic commerce and thus worked in transportation. This was determined solely based on the performance of work and not just working for a transportation company. Applying this test would mean that Bissonnette and Wisnowski also works in the transportation industry. The question is if the employee must work for transportation company in order to be in the transportation industry and thus exempted from FAA. A transportation worker does not have to work for a transportation company to have this classification. The Second Circuit decision was vacated, meaning that Bissonnette and Wisnowski are exempted from FAA regulation. They can move forward with their class action claim against the company. They do not have to arbitrate individually.